Well, I thought it was fair. It was a little higher than what we had hoped for, but I knew that jail was a likelihood. I was hoping that he could serve it on an intermittent basis, but between 90 days of what we were asking for and 120 days, we came close, and it was certainly a lot better than 3 years, which is what the Crown was asking for. So Mr. Suter is content. In fact, Mr. Suter and his family and the whole defense team are content that finally the one objective observer who's seen it and heard it all has declared that Mr. Suter was not guilty of impaired driving and that Mr. Suter was factually innocent of impaired driving. And we want that clear and we want that publicly repeated so that there is no further any false assumptions or false narratives about Mr. Suter and this allegation that he was impaired by alcohol that day.
How about the danger he faces now in jail?
Well, he is now in the hands of the correctional authorities. They have a job to do. They have a duty to protect Mr. Suter. The judge's comments have also warned that he must be placed in protective custody, and I think they're going to take their job seriously. So although Mr. Suter and his family are worried about that, I have every confidence that the correctional officers who are in charge now will take care of him for these next few months.
At the end of his sentence, do you think he'll ever be able to put this behind him?
Well, today is a good start. He will serve his sentence. He will pay his debt to society. He was vindicated today, and I hope you're all aware of that. He was vindicated by a judge who heard it and saw it all, and he was vindicated. So he is looking forward to the rest of his life. This will come with some adverse effects. He will be looking over his shoulder, and so will his family. But hopefully the threat on his life and his health and on his family's health and life will dissipate now when people with an open mind finally realize, at long last, that he was not impaired that day.
Did you get an opportunity to speak to your client afterwards, sir?
Yes, we just went down to see him and spent about 20 minutes with Mr. Suter. Of course, no one likes to go to jail, but he took his sentence stoically. He understands. He also understands and appreciates that the judge saw the evidence our way, and that when it was a contest between whether he was impaired or not impaired, that the judge accepted Mr. Suter and his wife's testimony that he was not impaired, and that the other people, although honestly believing impairment, were working on a false assumption simply because of the horrific nature of the crash. So he is, as I said, he's satisfied. No one likes to go to jail, but he's relieved that the worst is over.
As I'm sure you saw, after the judge left the courtroom, there is still so much anger. Does that surprise you?
No. The family will never get over this. This case, there's no winners, there's all losers. It's a case of destruction, death, despair. The family of the deceased, that little boy, will never get over it, of course, and we all feel terrible about that, of course, and Mr. Suter and his wife do too. I'm not surprised that some will leave the courthouse angry and upset, but we just hope that at the end of the day, some open-mindedness will prevail and some people will be persuaded finally that Mr. Suter was not impaired. He caused a terrible accident. He took the life of a sweet little boy, but it was by an accident, not by criminal conduct.
There is an anti-impaired driving advocate, Sherry Arsenault, who attended the hearing with you today, who is concerned that the general public may get the wrong impression that not refusing to blow is an easy way out.
Well, you saw that it was not an easy way out. In fact, Judge Anderson concluded that he would have given him a sentence similar to what an impaired driver causing death would have received had we not bridged the gap and shown that Mr. Suter, through his testimony and expert evidence and expert testimony, was not impaired. But we had to bridge that gap.
The onus was on you.
The onus was on us. We bridged the gap, and he still went to jail. So it's no easy way out. And in fact, I think Judge Anderson was really coining a new piece of advice that lawyers in those situations will have to give people detained or arrested for impaired driving causing death, which is, look, if you don't blow, it's as bad as if you do blow, because they both come with a maximum of life imprisonment. So from this point forward, people will not have this misunderstanding, and lawyers, I suggest, will be duty-bound to provide that caution to any arrestee who is asked or demanded to provide a breath sample. So I think Judge Anderson has advanced the law and coined a new warning or a new piece of advice for lawyers to provide people in Mr. Suter's situation.